excuse warrant judgment
Good.
in the matter of a tax settlement.
All right. So, Your Honor,
Disposition in the equity for all.
So, just for the record, I saw Ms. Deal, who I recognize from prior appearances, being brought in by prisoner escort, but wouldn't come in through the courtroom. Comments about she would not, essentially, that she would not enter the courtroom.
that's right. And so the officer came up to me and he's asked if they should bring her in and put her into the prisoner's box using force. And I asked if Your Honor for some guidance. I don't. My position is I don't particularly have any preference on where she stands, except that it respects officer safety and safety considerations of anyone else in this courtroom. But
Ms. Deal was also making some statements and continued to make statements, and she would be disruptive if she continued to remain. I want to address something. On September 13th, in M15, I judicially pre-tried this matter, and when I saw her name on the docket, and then I saw Mr. Neal, and he mentioned about the amicus, potential amicus, and I looked at the information. I saw that I signed 486 order on that day. I also listened to the DRD, and it was indicated that the matter was held down because she had been in custody for a period of time. A fitness order had come back. She was found fit. And because she had been in custody without bail, or having a bail hearing, a quick in-custody trial date was obtained. And it was noted on the record that neither myself nor Justice Crawford could be the trial judge. So there's clearly an administrative error, unfortunately. And I couldn't begin to be the trial judge unless Ms. Deal gave meaningful and informed consent. And I'm not sure that's going to happen given her unwillingness to participate so far in what's transpiring today.
So, given, I know we have a number of judges in the building. I do have a couple of officers and witnesses, and based on my prior experience with Vanier, where they would not bring her to court if she doesn't comply. The only reason we have her in court today is because she was at CLU. My preference would be to attempt to do this trial today. If I could be given a few minutes to reach out to court's administration and see if there could be a shuffling of matters in this courtroom or in this courthouse. If not, then we're left with the only option is to adjourn to a different day, potentially tomorrow, but a different day.
Well, that may depend if she's willing to come into the courtroom. Mr. Neal, I know you're not officially amicus, but I just had a question of you. I see you're in the body of the court. I know you had another matter in this court today. There is a 486 order that was signed by me. Did you accept that 486 order?
I did not accept that 486 order.
I see.
Okay. So she amicus and 486 shouldn't cross over.
And she can't cross-examine. There was a 486 order because they're criminal harassment charges.
That's right. So on application of the prosecutor, there's an order. There has to be an order.
There is an order
that she can't cross-examine the accused or the victim. I've spoken with the victim. I'm of the view that he's able to give a full, candid version of events without the assistance of any kind of counsel. And in any event, I have my confidence that she'll accept the assistance of any counsel is zero. And I don't believe I'm going to be requiring it in any event.
No, and if I'm not going to be hearing the matter, it's not ultimately up to me, but I don't have the code in front of me, but I had thought criminal harassment and 486 appointment is mandatory. upon application, and I'm not sure that the defendant needs to accept 486 counsel. 486 counsel isn't the defendant's lawyer, is a lawyer appointed specifically to cross-examine them.
That's right, and I take your 2 points. There may have been a prosecutor at some stage of the proceedings that asked for that. It may have been me, I'm not entirely sure. At this stage, I don't believe I'll be requiring one, and thinking about the practical realities of how an amicus would assist, an amicus would have to take instructions from the client on which questions to ask potentially, otherwise they'll, yeah.
Sorry, an amicus wouldn't have to take instructions.
No.
Amicus doesn't take instructions to the client. 46 would have to take instructions.
If the trial judge, it has to be the trial judge who appointed amicus, and the amicus is a friend of the court to assist the court, not.
That's right. So with regard specifically to that 486, if one is or was issued, I don't think there would be any success in one getting a lawyer, but two having the lawyer receive instructions. Having an amicus on board to help with other issues that obviously have helped, and Mr. Neal is here today. But I don't have any confidence that a 486 is required or practically will be able to be used.
All right, well, I think the first step is, as you had pointed out, Mr. Alrahani, is to see, and I think is to see if, check with the trial coordinator, speak to the trial coordinator about another court being available today or tomorrow. This is set for a 2-day trial, I believe. And Mr. Neal, in the event that the trial judge, if there's a trial court available today or tomorrow, was inclined to make an amicus order, would you be available?
I promised the court I would be, so yes.
Okay. Okay, thank you. Let's stand down then to make those inquiries.